So my case is Edwards versus Aguillard, and the civil liberties and amendments are the teaching of creationism and evolution are at play, which broke the First Amendment, and to specify, it was the freedom of religion and speech. And this all kind of started when Darwin challenged the fundamental religious beliefs of millions of people, and Protestant fundamentalists condemned his theories and wanted them banned from public schools. So in Tennessee, during 1925, the Butler Act was established, and this act prohibited teachers in any public academic setting to teach the theories of the Bible, which is creationism, and instead that we were descended from a grander species, which is evolutionism. And a certain small town within Tennessee called Dayton wanted to generate tourist income, so they recruited John Scopes to challenge this law. And this brought national attention to Tennessee and towards this rejection of the law, and people began to flock to Dayton. And overall, the Butler Act was restrained by the negative press and experience of the Scopes trial. Eventually, the teaching of evolution became legal in all states, but many teachers chose not to teach it due to the chaos that had been resulting from prior issues, such as cases like the Dayton, Tennessee one. So, in the late 1980s, Louisiana passed a law requiring that creation science be given equal treatment in schools, and this law was then challenged and brought to the Supreme Court. So, this case that was brought to the Supreme Court is, as we know, Edwards versus Aguillard. And these two lovely gentlemen and the lady are some of the most important people among this case. And on the left is Edwin Edwards, who's on the side of Louisiana. And on the right is Don Aguillard and Susan Epperson, who were on the side of the state. The amendment issued for this case was the First Amendment, where it prohibits the making of any law respecting an establishment of religion, impeding the free exercise of religion, or abridging the freedom of speech. So the state, represented by these chimps and humans, argued that summary judgment was inappropriate because there was a question of fact as to the religious nature of creation science. Their law in question was that it should be required that scientific evidence of creationism be taught, but not religious aspects. So Louisiana, which is represented by, I guess you could say, God looking over the earth, argued that summary judgment was appropriate because there was no question that the intent of the law was to advance religion. The law in question for them was that the secular purpose recited in the statute of advancing academic freedom was not a legitimate one. And the law singled out one monotheistic religion-based theory of the origins of life and excluded all others. And this case was brought upon the Supreme Court because it basically became an argument of what schools could or couldn't teach based on creationism versus evolutionism. The end result of this case was in favor of Aguillard, and in a 7-2 decision in the Supreme Court, the state of Louisiana's Creationism Act, as it can be called, was considered unconstitutional, and Aguillard won this case overall, but one of the decisions afterwards was that only private schools are allowed to teach and educate upon the creationism ways, while public schools may not.